Walter Smith on his feet in that courtroom. The state has officially rested its case, and now Mr. Walter Smith is making his delayed opening statement to this jury.
And simply by reserving my opening statement, I'm not trying to separate my client from everybody else in these matters. My goal here is to educate you on what our position is, what our theory, if you will, of the defense is. And in order to do that, we have to call witnesses to come in here and testify. And that's sort of my role in this case. Mr. Crawford over here is handling the closing argument. That, in our order of battle, we felt that it was best for each attorney to be assigned a certain task and to fulfill that so as to save you from as much time as possible in considering this case. And we see that two of my younger colleagues, more energetic colleagues, Mr. White and Mr. Graham, have a skill for cross-examination. That's been their role in this case. Mr. Somathy is our team doctor. He knows the medical testimony, and he asks the medical witnesses the pertinent questions that you need to have answers to in order to resolve this case. Mr. Dingus, he knows the videotape backwards and forwards. He's going to help us in presenting our case to you by actually showing the video, and so that our clients, when they testify, can explain to you exactly what was going on in that exercise field back in January. Ms. Benedict is our legal scholar. She's been making most of the objections and arguing the legal points in front of the judge. And Mr. Pell, who's examined a couple of witnesses, his forte and what I expect he will do in closing and probably in asking some questions of our witnesses, is talking about the whole concept of use of force and whether the actions taken by the defendant out on that exercise field were the proper actions. So this is sort of the order of battle. Now I'm not good at any of those things. So my job really is to get the witnesses here, get them subpoenaed, and tell you what they're going to say. And that's what I'm going to do right now. I have mostly been a spectator to these proceedings, taking notes and watching you, and I can tell that a lot of this information is overwhelming. A lot of the information dealing with medical causation, proximate cause, culpable negligence, all these legal terms that have been bandied about are very difficult to understand, and it occurred to me nobody's really stopped and told you what those terms mean. The judge read you the instructions, and I know that all of you were listening patiently to those instructions, but I think it's a great leap of faith at this point to believe that you all understand what these concepts mean. We've talked about exertional sickling collapse. We've had witnesses talk about it. We will have an expert come in and talk about it, but it really doesn't mean anything unless it is placed in the context of a defense. And so that is what we are about to embark upon, to try to establish through the evidence and testimony and the law that each and every one of these persons who's accused of this crime actually has a defense to that crime. And we have to make you understand why we have a defense to that crime. And if we are successful in doing that, naturally, you would have to acquit each and every one of these defendants. When I talk about the defense, bear in mind this one fact: this is a multifaceted case, and the defense is multifaceted. There are defenses that I'm going to be talking about that apply to all of the defendants, or in your mind may apply to only one or two of them. The charge in this case is one that carries with it what's called certain lesser included offenses. So even though we have 8 defendants, we have one charge, you will be asked to deliberate on lesser included offenses, and so that each verdict form, and there will be a verdict form for each defendant in this case, will have 5 possibilities on there. So there's a total of 40 different verdicts you could find in this case. I expect that all of the defendants in this case will testify. So I'm standing here right now. That is what each attorney expects to do, to call his or her client and ask them some questions about what happened that day, what their involvement was, and of course each person who testifies is subject to cross-examination. I think that in this case each defendant will be subjected to rigorous cross-examination by these able prosecutors here who have incidentally, very professionally and economically put on this case before you. We expected we'd be here probably 2 or 3 weeks with this case, and as I speak, I think we're probably going to finish this case up about Thursday. So we've made remarkable progress through the cooperation of the defense counsel and also the expertise of the prosecutors in presenting this case. But I'll remind you of this. Remember what the judge said. No juror should ever be concerned whether a defendant did or did not testify. In other words, I could sit down right now and say, Judge, we rest. We're not going to call any witnesses. We're not going to call our clients. And you would be left to decide whether, in this case, the state's evidence has proven the guilt of Charles Enfinger, my client, or any other client beyond and to the exclusion of all reasonable doubt.
And a reasonable opening statement thus far. You're in for a treat because he's just getting started. We're going to take a very quick break so we don't miss the heart of it. Stay with us. We are live in Florida for the boot camp case. Did 7 drill instructors and a nurse cause the death of this young 14-year-old